I don't know why. Hang on.
Beautiful. I'm jealous. I wish my office looked like this.
I assume Ken's going to kick us off. Is that your assumption, Sam?
I believe so.
Okay.
Angela, it's Judy from MMCRC. I'm trying to get where there was some confusion, and I'm trying to get Ken over.
Okay, thank you for letting us know.
Do you want me to pull up the PowerPoint presentation?
I actually think it'll be okay. I think I can do it on my end.
Okay, Samantha.
Thank you, though, Judy. Appreciate it.
Sure. Mm-hmm.
Yeah, I had logged into the Zoom link like at 9:55 or something and kept saying waiting for the host. I emailed Ken, what's happening? And then he emailed me back and he's like, where are you? I don't know. Apparently Zoom doesn't like it when you're early. Got to sign in on time.
Yeah, I was early too. I took the moment to water my lawn real quick during that first few minutes.
Yeah, before it gets super hot, I just looked at the weather and it's supposed to be 104 in Portland today. Ugh, scared.
Yeah, we're in Portland. It feels hot.
It feels hot already. I'm already kind of sweating. It's like, oh no. Well, I'm happy to kick us off if we want to just go ahead and start with my section, and then Ken can kind of pop in and add whatever he'd like to after I kind of go through it. So let me see if I can.
I think that's a good idea.
Share my screen and get this going. Okay. Now, is that sharing the actual PowerPoint now, or is it still can you see the whole screen, or is it still
It's in presentation view.
Perfect. Okay.
Yep, looks good.
All right. So my name is Samantha Sheehan. I'm an attorney for the Oregon Law Center. And I'm here to kind of share some legal updates with you guys, some important legal considerations to think about. And yeah, this next page will have some more information about me. So my name is Samantha Sheehan, like I said. My position is a special position that is actually funded by the special assessment that you all pay as part of your tenancy in a park. That was contained in a statute that the legislature passed a few years ago, and it took quite a few years to get the position filled, unfortunately. And we all know that the legislature has struggled to get things done this session, but very luckily, they did get the House Bill 3151 passed. We're just waiting for governor's signature, but that does expand and extend my position. So I will continue to be able to provide these services to manufactured home park tenants through 2027. And in the extended position, right now, basically, I'm just representing individual clients on my grant. And then through OLC, they have been paying for me to do tenant trainings and, build materials and things like that. And so we actually extended the position, the legislature did. So now that will fall under the grant as well, which I think is really great. That'll give me a chance to really create good and useful materials so that you guys have a better understanding of what your rights are. Today, we're going to be talking only about facility tenancies. So, you can live in a park and not be a facility tenant. A facility tenant is someone who owns their manufactured home park, or excuse me, owns their manufactured home, not the park, owns the manufactured home and lives in a park. And so a park is defined as a space where manufactured homes are loop together, and there's at least 4 of them, 4 or more. So if you are renting your manufactured home or subleasing your manufactured home, you do not have the same rights as a facility tenant. So I just want to make sure that that's a big glaring warning to anyone who may be renting their manufactured home. This law wouldn't apply to you. So it only applies to people who own the manufactured home and rent the space that it's sitting on in a park. And then the last little caveat here, this is not legal advice. Legal ethics rules very clearly state that lawyers cannot provide legal advice unless they are your lawyer, right? And so I'm not your lawyer right now. You have to call me and do an intake and sign a retainer, and that's what makes me your lawyer. What I can do is provide an overview of what the law says. I can talk about hypothetical situations, but I cannot apply the law to specific facts in your case. So if you do have specific legal questions, if you can frame those questions more as like a hypothetical rather than this is my exact situation, if you could say, if this happened, then what do we do? And then I can answer those questions a little bit more. It's just kind of a way to skirt that no legal advice and still provide you guys with helpful information. So a quick legislative update. Like I mentioned, the legislature had some issues this year. There was a walkout. They came back finally. There was a mad scramble to get things done. And thankfully, we got stuff done. So like I mentioned before, House Bill 3151, that extends my position to January 2027, meaning that you all will have access to an attorney through that time, which is great. It also, like I said, expands my position to include tenant outreach, presentations like this one, and the creation of tenant materials. Tenant materials would be distributed like through the OSTA website, on like Oregon Law Help, and can be distributed out also by legal aid organizations. Thankfully, I do have good connections with OSTA, and I get to meet with them pretty regularly, and I get to meet with Ken regularly. So when I get to create these things, I have a lot of awesome people that know way more people than I do that I can kind of give that stuff to for dissemination. So my hope is that we'll have a lot of good materials out there for you guys here in the next year or so. House Bill 2001, this is an incredibly exciting bill. So this bill essentially takes those pandemic protections for the non-payment of rent evictions and makes them official law forever. So instead of having a 72-hour notice, which if you've ever received a non-payment of rent notice, they're very stressful. You get them usually after the 5th or the 8th day of the month, and then you have either 3 days or sometimes 5 days, depending on when they give it to you, to get all of that back rent paid and cure your notice. Now, and that was basically impossible to do, right? If you got a non-payment of rent and you needed, say, rental assistance, there's no way you can get a rental assistance application submitted and processed and paid in 3 days. It's just not possible. So this law extends that notice period to 10 days. So on the 8th of the month, you can get that notice, and then you'll have until, say, the 18th of the month to pay that amount. If you don't pay that amount on the notice in that 10 days, your landlord can file an eviction against you in court. This law allows tenants to cure the eviction all the way up until trial. This is a huge difference, and it's really, really, really important for tenants because that gives you enough time. If you need to do a rental assistance application, you have the 10 days of your notice period. You'll have the 7 days after they file before your first appearance. You can then request trial, and you'll have, I think 2 weeks is what the law says now, 2 weeks before they set your trial. So you actually have a significant chunk of time to be able to collect the money that's owed and pay that to your landlord, and that will avoid eviction. So say you go to court, you do your first appearance, you ask for trial, you set a trial date, you show up at trial in the morning, and you hand your landlord a check before your trial starts, your case is dismissed now. So this is a huge benefit for people. Non-payment of rent used to be the most common way that people would get evicted because there's really no defense. As long as they got the notice right, there's no factual defense to it. If you owe the money, you owe the money, right? And so this is really huge for tenants to be able to avoid eviction in this specific area, the non-payment of rent. There are still organizations out there that do rental assistance, much less than they used to be during the pandemic, but they are out there. And so like up in Portland, Yanistar is great. They do a lot of great work up here. And like UCAN does some good work. But the official like state rental assistance is no longer available. So if you went to the Oregon State Rental Assistance Program page, that's going to say that it's paused right now. So you have to basically look for your local community action agencies to try and find that rent assistance. I still suggest when you get a notice like this, call me, call your local legal aid office. If you're receiving termination notices, the best thing that you can do is at least try to get some lawyer eyes on it. And if you go through either Legal Aid Services of Oregon or Oregon Law Center, where I'm based, we are free to tenants. So long as you meet our financial eligibility requirements, we can give you free legal advice. And so there's really no downside to at least trying to reach out to us and seeing if there's an attorney available to look at it, right? The worst thing that could happen is that there's not an attorney available and then you're in the same exact place that you were before, right? So it's always worth reaching out and attempting to have someone look at these notices. Another really exciting law is SB 611. This is lowering the maximum rent increase. So right now it's 7% plus AMI, which is basically a number that encapsulates inflation for the year. And that number comes out in September of the preceding year. So because inflation has been so bad after the pandemic, that AMI number was say like 9.4. And so we're looking at a much, much higher rent increase this year than we've seen ever before through the old statute. So that's what this bill does, is caps the maximum rent increase. So it's still going to be 7% plus AMI, but it caps it at 10%. So what I've been saying to people is expect your rent to be raised 10% every year. Just expect that, plan for it, budget for it, because they're going to continue to increase your rent every single year. And now that there's a cap on it, people that may have done it every 2 years, or, mom and pop parks that maybe, did a rent increase, but not to the full amount that they could, they're going to probably go the full amount now, right? Because they can't wait 3 years and then decide to raise it to market levels. They can only raise it at that 10% amount. And so I think it's going to be very likely that we see almost every single landlord raise the rent raise the rent 10% every single year. And so that's something that's really important to think about, especially for new tenants thinking about moving into a manufactured home park, realizing that, yes, your rent may be at this level and your mortgage may be at this level, and you budget that out against, say your Social Security or your pension or your retirement, and you think, okay, yeah, I can make it here 30 years. That's great. But you're not accounting for that continuous rent increase, right? And accounting for increased costs and utilities, right? So kind of thinking about and forecasting how much you're going to have to pay in these parks over time is really important to do. I see so many people that are basically getting priced out of their parks because we didn't have this law when most people moved into these parks, especially our long-term residents. And now they're facing a position where they don't really have any options. If the landlord keeps raising the rent, they're going to have to sell and do something else. And so if we can disseminate that as a rule to just please budget for the rent increases, just expect them. And if they don't happen, then yay, a wonderful surprise, but just expect them to happen, plan for them to happen. And that should help at least a little relieve some of that stress when you get that notice and you're like, oh my gosh, how am I going to pay this? Just expect that that's going to come every year. And do I have any questions about the legislative update before I move on?
Yes. I think Mike had his hand up.
Yeah, go ahead, Mike.
Yes. What is AMI an acronym for?
You know what? I put the wrong thing in here. AMI is average medium income. It should be CPI. Thank you for pointing that out.
Thank you.
Is the Consumer Price Index. Mike, thanks for catching that. So the Consumer Price Index is released every year in September, and that basically encapsulates, the inflation for the year.
Thank you.
Yeah, thank you. Thanks for catching that. That's AMI is the number that I use for assessing financial eligibility. So it must have just been stuck in my head. Do you have any other questions before I move on? Okay. So now we're going to go over some specific legal rights. So what I'd like to tell to my tenants is that the best way to preserve your rights and protect them is to know them, is to have kind of a sense of a smell test, right? So when your landlord does something and you're like, this seems off, right? The best way to have that sense of like, this doesn't seem right is to know what they're supposed to do, right? And to know what you're supposed to receive. And when that doesn't occur, then okay, it's time to call an attorney. And so I think really the best way, it's not like you are expected to solve all of your legal problems by knowing them, but this way you can assess much better when there really is a legal problem, right? When the landlord really is breaking a law, and then you can be like, okay, it's time to call Sam, right? So don't think you need to know everything, but having an idea of what your rights are and what your landlord's obligations are is a huge help in terms of being able to hold them accountable, right? So the things that we're going to talk about today are fee shifting, making a record, rent increases, which we kind of already talked about, the rights and obligations of landlords and tenants, and then evictions. So in terms of fee shifting, ORS 90, which is the Oregon Landlord Tenant Act, contains a provision that says, if you're in court on a landlord-tenant matter, whoever wins that case can make the loser pay their fees. Fees can include attorney fees, court costs, and other costs that are incidental to the litigation. As legal aid lawyers, we don't charge fees to our clients. However, we will charge fees to your landlord if we win in court. The fact that we have fee shifting in the law is really great in terms of trying to hold landlords accountable, because, for example, I won a case recently and sent out, they have to pay Oregon legal aid about $4,000 now, right? And so it's more than a slap on a wrist for the landlord when they do something wrong. It really is a financial burden for them. And so it helps them financially learn how to be a better landlord, right? Because it gives them, there's consequences, real financial consequences for their bad behavior. Unfortunately, the flip side is true. So if as a tenant, you try to fight your eviction and you end up losing, well, now you could be responsible for paying the landlord's attorney fees, the landlord's court costs, service fees, that kind of stuff. So it is risky going to court, right? Because once you're in court, fee shifting applies, and whoever loses that case may end up with a significant financial burden. Now, I'll say sometimes my clients are what we call judgment proof, meaning they don't have wages that can be garnished and they don't have assets that can have a lien put on them. So in those situations, having that judgment against you may affect your credit, but in all likelihood, they'll never actually be able to collect it against you. Whereas on the flip side, landlords do have the money and they do have wages you can garnish, and they do, right? So you're pretty much always going to get the landlord to pay. Whereas on the tenant side, it's kind of the landlord may or may not get that money back from the tenant. But that judgment will still be out there and exist and can affect your credit. So this is something that, you really have to take into consideration when you're thinking about whether you want to settle an eviction case or whether you want to fight it and go to trial. And also whether you want to file an affirmative case against your landlord, because that's always an option too, right? Your landlord has all sorts of obligations. And if they break those obligations, you can sue them and fee shifting will still apply in that case. So if you sue your landlord for damages and somehow we lose, or you lose that case, you could then be responsible for all of your landlord's fees. So going to court on these issues can be really risky in terms of financial liability. However, I want to just throw in a pitch that this area of the law doesn't have a whole lot of case law. So it's not really flushed out. There's a lot of definitions and terms that we don't really know the meaning of because the legislature didn't define them in the statute, and we don't have cases that explain them. That's primarily because taking these cases to court is really risky, especially for clients who own their home and then rent in a park, because you're stuck in that park, right? Theoretically, you can move your home, but not really. And then you're stuck with this landlord, and people don't always want to enforce their rights because they're afraid. And that's totally reasonable. However, the reason why we don't have a lot of law that's fleshed out is because people are scared and they don't want to take the cases to court. So I think, there's a balance here of saying, like, my personal safety, my personal finances, my personal, my home and my relationship with my landlord, that's a consideration. And then on the other hand, we want to think about what's the impact of actually making the landlord comply, right? If we take them to court and we force them to comply, what is that impact? Well, most of these landlords are managing more than one park. So now we maybe are affecting other parks in a really positive way, right? And so I think if we can think about ourselves as a community of facility tenants, and each time that we're doing something, that we're bringing a case, that we're bringing a defense, we're helping the entire community by setting standards, by setting examples, and by forcing these, especially these big corporate landlords, to pay some money out when they do things wrong. Yeah, it looks like Ken's got his hand up.
Yeah, I do. I want you, pardon my late arrival, whatever. Zoom doesn't like early attendance. But anyway, you mentioned affirmative action, and we had a issue with a tenant the other day. They went down to the court and they didn't know what an affirmative, action was, or is it called by another name?
So it would just be a regular civil suit. So what it would be is just like a complaint, essentially. Mm-hmm. And then you list out what that complaint is in the form. Now, I'm not sure that the court has forms that they would just hand you a form to fill out a complaint on. I don't know if that exists at all of our courts. I would not recommend filing a civil case unless you have an attorney, just because, again, the risk is really high that if you lose that case, then you're going to be on the hook for a lot of money. Mm-hmm. And it's easy to lose a case without an attorney because there's so many just weird, kind of dumb, specific rules about how you have to format things and how you have to submit things and how you have to present evidence to the court. And especially if the landlord is represented and the tenant is not, it's going to be almost impossible to get your evidence in, because if you don't know the rules of evidence to get them in, the landlord's attorney is just going to object to everything that you do. But my understanding is that it would just be a basic complaint. And in a basic complaint, you would list out the facts of the case, you would list out the law that is applicable, and then you list out what you're requesting, right? So you'd say my prayer, that's what we call it, it's kind of weird, but we call it a prayer on the pleadings. And you would say we're requesting attorney's fees, we're requesting this amount of damages, we're requesting an injunction against the landlord. So it's kind of the structure of those complaints. It's facts, law, prayer, sort of.
And I guess the other thing that people are, those same considerations are different for small claims.
That's true. So in a small claims case, there are no attorneys. You cannot have attorneys in small claims court. So the amount of fees that you may be responsible for is going to be much less in small claims than it would be in regular court if you lose, right? And then the fee shifting applies. So in small claims, it's less risky because all you're going to have to do is pay like the prevailing party fee and their court costs, which still could be a couple $100. But it's going to be significantly less, right, than if you had to pay a private attorney's fees, because they charge a lot of money, right? But yeah, so small claims is always a great way to try and kind of flush out these financial claims with your landlord without having that same risk of attorney's fees. That's a good point, Ken.
Yeah, I'm just reflecting on the feedback that I've received in terms of in small claims, do you have to show damages? How difficult is that, or is that not required?
You would still need to show damages, because so basically like small claims is you're going to say, look, this landlord owes me $600. And so you have to prove why the landlord owes you $600, right? And so proving damages essentially just means that you have to have a statute that says the landlord can't do it. And then you have to have proof that the landlord did do it, right? So an email, a picture, even testimony, that's evidence, right? So you just telling the judge what happened, that's evidence. I always recommend and we'll get to this later, but if you put everything in writing, when you go to small claims, you have evidence that you can put in that's not just your testimony. Because if all you're doing is speaking to the judge, then the landlord can just say that what you said is wrong, right? Like, and then it's a he said, she said type of situation where the judge just gets to pick who they think is more credible. If everything is in writing and you have physical evidence, especially like if it's between you and your landlord, right? Because that's not hearsay, because both you and your landlord are there in court. So you can submit that email as evidence. So that I think that's really crucial in terms of when we're thinking about how do we prove these kinds of damages, you got to build a record. So that's kind of the next thing that we'll talk about. So does anyone have questions on fee shifting before we go off to making a record? We can still kind of keep talking about the court process.
Well, John mentioned that keep in mind, small claims court, the defendant can bump to the circuit court.
Yes, that is true. Good point, John. All right. So here, making a record. So this is kind of what we were talking about before. I highly recommend just do all of your communication between you and your landlord in writing. It's not a requirement under the law. So, the landlord can try to talk to you or call you or whatever. If that happens and you do answer and you do have a conversation with them, send an email or a text message immediately after that conversation that reviews the conversation that you had with the landlord. So if you have a conversation on the phone and the landlord says, oh yeah, of course, you can plant all those shrubs there. That's a great idea. I love that. Send them an email saying, hi, per our phone conversation today, you mentioned that I requested permission to plant shrubs and you said yes, thank you, right? So you just give them the opportunity, put it in writing and give them the opportunity to say, no, I didn't give you permission, or yes, I did give you permission. Or, if they don't respond at all, then, we can think of that as an admission because you gave them a chance to say, no, I didn't give you permission. And they didn't tell you that you don't have permission, right? So this is one of the best things that you can do to protect yourselves. I can't tell you how many times I've seen clients who have, built a new fence or built a new shed or done something that was a significant financial investment in their space. And then the landlord comes around and says, I didn't give you permission for that. You have to take that down, and gives them, termination notices and takes them to court over it. But they gave them oral permission, but there's nothing in writing. And so all you have is the landlord saying, I didn't give them permission, and the tenant saying, but yes, you did, right? And then again, it's just the judge deciding who's most credible. So by putting this stuff in writing, you have the opportunity to, when the landlord says, no, I didn't say that, you can say, Your Honor, I have an email here from my landlord that says he did say it, right? So you can kind of contradict that, whether the landlord is lying or bending the truth or whatever it may be. You have an arsenal of emails and text messages. You have all of that communication in writing. So if the landlord says, oh, you didn't give me notice, or I didn't give you permission, you have proof that they did, right? And so this is a really, really important part of protecting yourself throughout your entire tenancy. A lot of tenants, when they have a nice landlord, they'll be like, well, I don't need to do this. I love my landlord. But what happens if that owner sells your park? And now you have a new owner, and that new owner and new management company are really mean, and they don't want to work with you. And you don't have all of the proof and the permissions and all of the things that from your old landlord. And this new landlord is like, this is wrong. This is out of the rules. And, it can become a whole big messy situation. So having all of that stuff in writing is one of the best ways to protect you, even if it's something small. Having it like, I didn't receive my rent receipt this month. Please send it to me. All of that stuff. If you put that in writing, you're building a record of every time your landlord is breaking the law, of every time your landlord gives you permission to do something. And so you've got that record where you can not only show the judge, but you can, even show that to your landlord before you even make it to court, right? And be like, excuse me, landlord, you said this on this date. Let me forward you that email. And that can be really helpful, right? I think, I talked about this a little bit with the tenants last night, but landlords will push and push and push. And if they don't get pushed back at all, they're going to just do what they want to do. Now, I don't think that all landlords are bad people, but I do think that they're businessmen and women, and they're out there to make money. And a lot of these laws make it slightly harder, right? They have to jump through some hoops. They have to give out notices. They have to do stuff that may cost them some money. And so if they can avoid doing that and get what they want to have happen without jumping through all the hoops by just asking you to do it or telling you to take something down, then they will do that, right? So I think it's really important that all of that is in writing and that you continue to hold your landlord to account to what they've said before too, right? It's not just important for court, but important for your relationship with your landlord in terms of holding them accountable. Because I think there's a lot of different layers here in terms of making sure that these facility landlords know that tenants understand their rights, and tenants are going to stand up for their rights, and they're not going to let the landlords walk all over them. And if we can really, as a community, push that, push that story and push that, like, this is what's actually happening in Oregon. These tenants are going to fight back. They do know their rights. That's going to make landlords a little bit more on edge and a little bit less likely to do some of the shady stuff that they're doing. So making a record is great. It's also one of the most exciting things that an attorney can get when you come to us and you say, I have these problems, and you send us this record with all the proof that we need and all of everything in writing. It's great. So please do this. I think it's great for before an attorney gets involved. It's great when an attorney gets involved, and it's great when you're in court. So there's really no downside to putting your communication with your landlord in writing. Rent increases. So we kind of talked about this a little bit before. And again, I put AMI instead of CPI. Thanks again, Mike, for catching my mistake. So it's 7% plus the CPI for the year with a max cap of 10%. This bill still needs to be signed by the governor. So it's not in effect right now, but it will be soon, presumably. One thing that is important to note is that when you sell your manufactured home, there's a new tenant coming in. So a new tenancy is starting and a new rental agreement is being made. The landlord is not required to follow the rent increase amount for the new tenant. So if you pay $650 in your space and you want to sell your home to a new tenant, $650 is not going to be the rent that that new tenant pays. The new tenant will be paying whatever market rent is. The park I was at last night, they said they're all around like $550, $650 for rent, and that they're selling the new houses or putting new tenants in the homes for $900 a month. So that is something to really think about when you're thinking about selling your home, is that the new tenants aren't going to have the same rent space or rent amount as you. So sometimes that can be a big barrier in selling your home, because if rent is so expensive, they're not going to be able to pay as much for the home itself, right? So that's just, it's kind of an unfortunate aspect, but it is what the law says. And so it's really important that when you are thinking about selling your home and thinking about what kind of profit you can make off of that, that you take into account that the person who buys the home is going to be renting it at a much higher amount. And, that may deter some buyers from taking your home. And I know that some people have had some trouble selling their home because of the higher rent amount for the parks. So it's just something to take into consideration when you're thinking about selling your home, that, you may end up needing to reduce the price to actually get it sold because that rent is so much more than what you were paying. And does anyone have questions on rent increases or building a record before we move on? Seeing none, I shall move on. All right, so rights and obligations. Landlords and tenants have lots of rights and lots of obligations under the law. If I were to talk about every single one, we'd be here all day. So I'm going to give you a brief overview of kind of the important things that you must do as a tenant and the important things that your landlord must do as a landlord. So first, you got to follow the terms of your rental agreement, and you got to follow the rules and regulations of your park. Often these documents are very long and full of legalese, and that sucks, but it still is your obligation to follow those documents. And so I think it's really important that you have those documents on hand, that you keep them in a place where you can easily access them, and that you review them from time to time. If you receive a notice or like a violation or anything from your landlord relating to saying that you are breaking a rule or regulation or your rental agreement, pull that out and double check and make sure that that's actually in your rules and regulations and in your rental agreement. Tenants must also pay rent on time. So I know that in parks, landlords often provide an invoice that has your electricity on it, your water usage, maybe a meter cost, whatever it is, right? It has all of these charges on it, including your rent. Some people mistakenly believe that that is the bill to pay rent, but that's not exactly how that works. Rent is always due on the first of the month, or it depends on what your rental agreement says, but generally speaking, it's due on the first, and it's always going to be due at that time. So whether your landlord makes a specific demand to you to pay the rent that month or not, you're still responsible for paying it. And if you don't pay it on time, you can get a notice of non-payment to terminate your lease, right? So even if, like say, landlords going through some stuff, they changed some meters, what's happening, they didn't send out the normal invoice, still pay your rent. You might not know what your utilities are or your rent is, and that's fine. Those things are payable on demand. Rent is not. Rent is always payable, is always due on the same time every month as stated in your rental agreement. Tenants must also report issues to park management. So if things need repair, if there are hazard trees, if there's leaks, if there's not enough lighting, all of these kinds of things, they need to be reported to park management. By reporting these issues to park management, it does then put an obligation on the landlord to fix it, so long as it falls under the landlord's obligations for habitability. Tenants must also maintain the condition of their own manufactured home. So this is something that's very different from regular tenancies, where when you're renting the actual space that you're living in, your landlord has the responsibility for keeping that space in a habitable condition. However, because you own your home and you're only renting the space, that obligation falls on you, the tenant. So, if you've got a clog in your sink, that's on you. If, the paint is chipping on the outside of your house, that's on you to fix, right? If you don't have skirting, that's on you to fix. So the condition of your home, that is your responsibility. I will also say that pretty much everything that's on your space and under your space is also your responsibility, meaning, where you have a connection to your space for water and electricity, that connection is the landlord's responsibility. But the pipes that, connect into the connection and go under your space and to your home, that is your responsibility. So you can kind of think about it. If it's on my space or under my space, that's me, the tenant, that has to do. There are a few exceptions to this. So if the landlord had built structures or planted trees, things like that on your space before you moved in, then those kinds of things would be their responsibilities, particularly the hazard trees on the space. Landlords must follow the terms of the rental agreement as well, right? The rental agreement is a contract between you and your landlord. And yes, there's a lot of law that surrounds that contract, but at the very base of what it is, it's an agreement between your landlord and yourself, and both of you guys have obligations and rights contained in that document. Landlords, as I mentioned before, must maintain the rented space, vacant spaces, and common areas in a habitable condition. Like I mentioned, the hazard trees, that's basic. If it's a hazard tree, then it's uninhabitable. So that's a pretty, not an easy one to have landlords fix, but if an arborist comes out and says that's a hazard tree, then that's a hazard tree, right? So it's relatively easy to prove that is the tree is hazardous. And like I mentioned, the connection to water and electricity on the rented space, that's the other main responsibility that the landlord has to your rented space itself. And again, that's just the connection to the space, not the pipes that go from the connection to your home that are contained on the space. That is your responsibility. If a landlord wants to change rules or do a rent increase or serve you termination notices, they have to provide very specific notices and serve those to you. And, service is a specific legal process, and they have to do that right. The notice has a lot of specific legal requirements in terms of the language that's included, or, sometimes they have to put resources on there for you, right? So there's a lot of different, very specific legal obligations that landlords have in terms of making a notice correct and valid. And something that we do a lot as legal aid attorneys is represent on notice defects. So, I had a case recently where they didn't add the 3 days, right? Because if you send something by mail, you have to add 3 days to it. And so they added 3 days to one of the dates, but not the other date. And so we actually won that case, right? And the landlord was really mad because they said, oh, it's just a clerical error, blah, blah, blah. But who cares? A clerical error, you were about to evict someone for a clerical error, so I don't feel bad for you. But so those kinds of things, you can actually win an eviction case based off of the landlord failing to do one of the many things that they need to do on these notices. If they do any one of those things incorrectly, then that notice is invalid and we can get that case tossed out of court, which is really great for tenants. The same goes for, like, if they try to increase your rent and that rent increases over the amount that they're allowed to increase, then, that's invalid. And there are damages and things for tenants when that occurs. But so there are very, very specific rules for the landlord about the form of these notices and how to get these notices to you. And if mistakes are made in either one of those areas, then you as the tenant can win your case. Landlords are required to provide a receipt for rent payments, but only when requested by a tenant. And landlords take the position that you can't just say once, like at the beginning of your rental agreement, I want a receipt every single month. You have to ask for it every single time that you pay your rent. Some landlords might be willing to work with you and agree to give you receipts every time, but that it's not required under the law, only when requested. And most landlords won't go above and beyond. So, I always recommend that when you make your rent payments, just send the landlord an email or a text message at the same time saying, I just need my rent payment. Please send me a receipt. Having receipts for your rent payments is really important because I've seen quite a few times landlords, send out a notice of late fees, or like a notice of your account is not in balance, and there's all these late fees on it for late rent fees, but they don't, their invoices, that their records aren't great, and the tenant doesn't have great records, and so it's really hard to prove that those payments weren't actually made late. But if, again, going back to making a record, if you're building a record of when your rent payments were made, requesting the receipt from your landlord and putting all of that in writing, then you're developing your own, like basically your own system, your own accounting system for your own rent, so that your landlord can't make accounting mistakes and then screw you over, right? And so again, this is a business transaction between you and the landlord, meaning the landlord isn't your friend. They don't have your best interests at heart. They're just running a business, and businesses sometimes make mistakes. And the way that businesses usually recoup those mistakes is to try and get the money from the tenant. They don't often say, oh, this was our mistake, let's just write it off, right? So if you have the ability to show your landlord, excuse me, landlord, I made this payment on the first, I made this payment on the second, I request, you've got the paper trail to show them that you don't actually owe any of those fees. And then likely they're going to at that point be like, oh, our bad, right? Because they're not going to take you to court if they know you have a full record of your payments, when they were made, how they were made, and that you requested receipts, right? So again, building that record is just a really good way to protect yourself from kind of the nonsense that landlords can do sometimes. Also, landlords must provide 24 hours notice to enter the rented space, except for the purpose of delivering notices. So if they were to personally deliver a notice to you or tape a notice on your door, they're allowed to do that without giving you notice. But they can't just say, come over to your house and knock on your door and like yell at you about something that you're in violation for. That is definitely not allowed. If landlords are trying to come onto your property and talk to you, you can say, please send me an email. You did not give me 24 hours notice to enter my rented space. Please leave, So again, it's like, these are things that if you know your rights, you can just assert that that's my right. They know that that is your right as well. They just don't know that you know it. So they may come on, they may talk to you about things. They may give you an informal termination notice or something like that. An informal violation notice. So if you can kind of just be like, no, get off my, like, we can't talk. You need to give me 24 hours notice if you want to come onto my space. And you can also be like, I'm not available to talk in person about this issue, but please email me, right? So that's, I know that quite a few managers, park managers take that position where they like to just go to people's homes and tell them what they're doing wrong. So I think, being able to protect yourself in that sense of saying, excuse me, manager, you cannot come onto my property, and please just send me an email or a letter with what this is, right? And they might not be happy about it, but it's your right to not have those conversations with them in person. Yeah, Ken. Oh, it looks like you're on mute, Ken.
Okay. John mentioned that the legislature changed the law regarding delivery and maybe he might mention that now, get to the specifics.
You know, I am not actually familiar with what that is, but if John wanted to share about that, that would be great.
I do.
John.
And I will.
Thank you, John.
And I wouldn't expect you to know about it, Samantha, since it just passed recently. So two things passed in the 23 session, which are important for what Samantha has been covering here. One is that non-payment of rent notices, which apply to all tenancies, not just apartment tenancies, but also park facility tenancies. Non-payment of rent notices went from being 72 hours to 10 days. So the notice can't be given sooner than the 8th day after the rent is due. I want to correct one small thing that Samantha said. It's unlikely to happen, but she's correct that rent cannot be due sooner than the 1st of the month, but the landlord could make it due later.
Yeah.
For example, if you get your Social Security check usually on the 5th of the month, the landlord, a nice landlord, might agree to make rent due on the 5th. So the way non-payment of rent notices work is that if you don't pay within 8 days, but 7 days of the due date, on the 8th day, the landlord can give a termination of rent notice saying, pay the rent within this period or your tenancy will be terminated. That period was 72 hours. It's been that way for God knows forever. And that law changed, and that law is already in effect. That law changed it to 10 days, and it allows a tenant to pay the rent up until judgment is entered. So the tenant could go to court, say, I've got the money now, here it is, I don't get terminated. The other big change that I just hinted at, or email Kent about, is that Senate Bill 1069, this was requested by the landlords, will allow both parties to use email to deliver notices. Delivery of notices has been very picky. Samantha already mentioned nail and mail. So before this bill passed, they could only be delivered in a couple of ways. In person, which means actually in person, doesn't mean sliding it out the door. Handed it to somebody in person. First class mail with 3 extra days added, or nail and mail, in which case you nail a copy to the front door or attach it to the front door and mail a copy. And in that case, you don't have to add 3 days. So we've added a 4th way, which is now going to be email. And email is effective when the landlord, and tenants can do this too, can also use email to give notices. The tricky part is that for termination notices, which would include non-payment notices, the landlord must give it to you in both email and first-class mail. Okay, so and it counts. The period starts to run, which now is longer, of course. It's 10 days or 30 days. The period starts to run when the landlord has done both, emailed and put it in the mail. So that's a big change. Landlords wanted it. They didn't want to also have to do mail, but that was the deal we cut. Mail, by the way, means first-class mail only. It does not mean certified mail or registered mail or anything else like that. It's first-class only. So I'll stop talking, and I don't mean to look over Samantha's shoulder.
No, I appreciate it. John is the best person to have looking over your shoulder because he pretty much knows it all. No, that's great. And so, John, does that mean that the email and mail is kind of like a nail and mail, basically, so that you're not getting the 3 days added?
That's correct.
Okay, great. All right. And do we have any other questions on rights and obligations? I know this is a very brief overview of rights and obligations. Like I said, if we went through everything, we'd be here all day. But I'm happy to answer any questions that you guys may have.
I have one.
Yeah, please, Rob.
I understood. It sounds to me as though a manager or a park owner or whoever it might be can make any change they want to the R&Rs as long as they follow procedure and notify us in the proper manner. Am I understanding that correctly?
So it can't be any rule. There are specific things that a landlord is allowed to change, what we call unilaterally. And in that case, they do have to provide you with notice. It's a 60-day notice before the new rule would come into effect. And the notice that they send has to contain a provision that explains the fact that tenants can object to this rule change. So in 30 days, so it's, you've got a 60-day notice, the rule won't go into effect until the 60 days has run. From the day that the notice is delivered to, you've got 30 days as tenants to object to the new rule. If 51% or more of the tenants in the park object to that new rule, then the new rule will not go into effect. And the way that it works in terms of voting is that one tenant, like each space gets one vote. So if you have, say, 4 people living in your manufactured home, you don't get 4 votes. You only get 1 vote. But so that is how that works. And that's supposed to be the kind of the balancing act, right, of landlords being allowed to change rules and regulations, is that tenants have the opportunity to stop that from happening. Something that we'll talk about a little bit later that is a great way to kind of organize that type of voting and organize that type of response to these rule changes is to have either an informal tenants association, have an OSTA chapter, do a full formal committee of 7, right? Like if you have some organization happening in your park among tenants, then when you get that notice, you can send out an email tree or a phone tree, and you can talk to your other tenants about, do we want this? Do we not want this? You can even do it in like a petition form. So each person can sign, each space can sign on one thing, and you can send it to your landlord all together, or you guys can each do it individually. But that's basically the protection that you have in terms of landlord changing the rules and regs, is that you can vote it down.
We have sort of an unusual situation here. We do have an OSTA chapter and a resident relations committee and what have you. But right now there's this dispute coming up because we have new owners, and the new owners apparently online have their own R&Rs, and they don't necessarily jive with ours. And we're wondering, well, doesn't the contract that we had with the previous owners take precedence, or does it?
Yes.
Can the new owners come in and set their own rules and regs?
Right. So basically what that is like, you have a contract with the landlord. So old owner and you've got a contract. When a new owner comes in, essentially what the landlord is doing is assigning their rights and obligations to this new person. So that person is just stepping into the role of the old landlord. They can't unilaterally change your rental agreement or your rules and regulations. They certainly try, right? They will. They love doing that. But no, they can't just, and I've seen even landlords send out like a newsletter that says, hey, a reminder, here's this random rule you've never heard about and isn't in any of your rental agreements or your rules and regs, but follow it or you'll be in trouble. That's not a notice, right? Like that is not a rule change notice. That's not effective for anything other than scaring tenants into complying, right? And so I think that's the hardest part, is that people are afraid to say, no, landlord, that's absolute crap. And we're not doing that because that makes no sense and that's illegal, right? They're afraid of retaliation. And even though retaliation is illegal and there is, a defense for that and a claim for that, it is hard to prove. And so I get the fear. I think it's absolutely valid. And like I said before, I think as a community, we need to start thinking about, yes, we might be scared to go against some of these landlords, and it might be scary to try and push back. But at the same time, if we don't, and they continue to get away with enforcing rules and regulations and doing all of this informally, then they're going to continue to do it. And I think especially when we have new owners coming in that are these larger corporations, which is generally what they are these days, that it's even more important to hold those owners and those landlords accountable, because that has a trickle-down effect, right? Because they don't own just one park, they own multiple parks. And so if they're held accountable in one park and have to pay some attorney's fees or can't get away with anything, they're more likely to start doing the right thing in other parks, so they don't have to run into that headache over and over and over again, right? So yeah, like I said, it's just really important. Keep those rules and regulations accessible to yourself. And when the landlord says, oh, this is a rule, check those rules and regulations that you have. And if it's not on there, send the landlord an email or a letter, and it can be from your tenants association, right? And that just says, this is not a rule or regulation for our park. Thanks. Right? But I think, like I said, like putting that stuff in writing, making sure that the landlord knows that you know that that's not actually a rule. Those are really important, like, preliminary steps to holding that landlord accountable. And let's see, so say you guys do that, and then the landlord's like, I'm mad, and gives you a notice of termination for one of these rules that isn't actually a rule. Well, now you've got a great defense in that FED case, right? And now, but most people don't want to make it all the way to trial because they're afraid and they want to settle. They want to do something else. They're like, might as well just comply. It's less headache. It's less scary if I just comply. But taking the risk and really going to court and forcing them, like having a judge saying, landlord, you can't do that. That is illegal. And now you owe them a bunch of money. That is really effective in terms of, kind of curbing this bad behavior by landlords that we see.
Thank you.
Mm-hmm. Do we have any other?
It's Angela.
Yeah.
Can I add some?
Of course.
I just wanted to offer a story about what happened at my facility. And our landlord, we already had, an 8-page rules and regulations document that we all signed. And then at some point a few years ago, our landlord decided, wouldn't it be great if we added 16 more pages to that? And then basically the way they proposed it, the landlord proposed it, is he just said, here are the new rules. He did say, as the law requires, that you've got this 30-day window to vote to reject the new rules, but the law also requires the landlord to put into writing in this proposal the language of the existing rule that you have with them and what changes about this rule. And because they basically just were saying, forget the old rules, this is the new document. And they're also required to provide, I think, a list of the number of spaces or which spaces need to vote. Mm-hmm. Because as a tenant in a facility, sometimes we don't know who's renting, who is, which spaces the landlord owns, things like that. And so the other thing that our landlord did is he did not put the correct eligible spaces to vote. So he removed a bunch of people who are eligible to vote in the list that he gave us. So the proposal was basically not a valid, legally acceptable proposal. And because we were a good tenants group and we talked about it, people were angry. We talked about it and we're like, this isn't even valid. And so we just asked him to rescind it, and he actually did. And the work of going through and changing each individual, there were 180 rules already to begin with. So to be able to change 180 rules to say, hey, this is rule number 78, and this is how we want to change it. They just never bothered to do it again. So if that's helpful to somebody, great.
Yeah, I think that's a great point, Angela. And it's kind of goes to the point that I was making, that there's so many different steps and different ways along the line that we can hold landlords accountable. And when the landlords know that they've got a group of educated, organized tenants who are going to push back, they get a little scared, they're like, okay, crap. Well, what does that mean? Do we have to hire an attorney to do all of this stuff? And I think Angela's absolutely right. At a certain point, it's not worth it for them. And so they're like, whatever, we give up, right? And so, but it takes the tenants coming together and being like, no, this is not right. And we all know that it's not right. And you need to take it back, or we're going to get an attorney involved. And then they're like, oh gosh, okay. And maybe they'll be like, no, we're not wrong. And then they'll talk to an attorney, and then the attorney will be like, yeah, you're wrong. So I think, I really think that that's an important step, is and like I said in that previous slide, knowing your rights is the best way that you can protect them. Because in Angela's case, had you guys not known of that law, you wouldn't have known that that was an illegal proposal, right? And so you guys might have just decided, you tried to vote it down, but you didn't have the spaces, and and then that could have come into effect for all of you, not only because you didn't know that was illegal, right? And so it's by knowing it, and just by saying, excuse me, this is illegal, no thank you, you can really make a big change in your park or your marina.
Correct. And the thing there too is only a couple of us did know that wasn't allowed. And so it took an email chain, and it took, this was during COVID lockdown. So it was really tough to organize and meet anywhere. So we did everything by email and by Zoom. And, it took some work, but the key thing to remember is that you're going to have tenants in your facility that don't want to rock the boat and they don't want to do anything. But in this case, not doing anything is a vote to actually accept the rule. The way the law is written is you have to reject it. Doing nothing means you accept it. And I think that's a little unfair the way the law is written, but that is the law. And so it becomes on the people who care about not having to follow these rules to convince our neighbors, you don't want to follow these rules either. And here's why. So there is a little selling that has to happen, but yeah, just keep in mind that doing nothing means a vote to accept those rules.
Really good point. Yeah, that's absolutely true. And, I think too, a way to sell it to other people is it's not even just like, yes, you have to follow all these rules, but it's also now we have say 18 pages of ways that you can be evicted. Right. And so instead of thinking about it as just like, these are rules you have to follow, these are reasons why you could be evicted. And do you want to be evicted for this? So it's like, I think that if you can explain to people that they're not just rules that you have to follow, but these are rules that could literally ruin your life, that can help.
That's exactly how we positioned it to that language. These are, 180 new rules and ways to get evicted. And the other thing too, what does that say to your property value when it is time to sell and move on? Because you're new, if you allow that in your community to have, I think it was 16 total pages of rules by the time it was all done. And each page had, 20 or 30 rules. What does that say to any prospective buyer about what it's like to live here when they see that new rule? Now, granted, the landlord can give new rules to new incoming people. But if you're firm about saying to your landlord that that's not acceptable in this community, then the chances that they're going to try to pull that on the new people too is not as likely.
Yeah, I think that's right. And I think that really the bottom line is when you show your landlord that you know what the law is and that you're going to hold them to it, it really does change the dynamic. Because your landlord is approaching every issue with every tenant in a much more careful, considered manner, rather than just, maybe the regional manager got a complaint from the park manager who is also, lives in the park and has a group of friends and hates this other person. And it gets up to, it's like kind of trickles up to the top. And then that person ends up getting a notice. That's way less likely to happen when your park is organized and when your landlord knows that by giving one person a notice, other people are going to know about it and other people are going to have things to say about it. And they're more likely to fight that notice because they have that support of the group. I just think it really does change the dynamic when you have a group of educated and organized tenants in your park. And I think I saw another hand up.
It's me. I'm Sean. I work with MMCRC. I'm a program analyst, and I help write the rules. And one that, something that just happened recently is that we were notified because Judy's been handling the registration. And when she finally gets a hold of, some of them are really hard to get a hold of, owners, she'll find out the park has been sold. And we were never notified. And so, in writing the rules, we can only do so much without having to change legislature. But I think what often happens is, I think there was no notice sent. And when we were looking at the rules, the rule says the tenants have to go to court. We can't do anything, MMCRC. So, I was just wondering in that situation, if the park was sold a year ago, we can't reach out to the tenants and say, hey, you know what, you could get 10% of the sale. But I think your point is very good about, the other part of the notice or the rules say the tenants have 15 days to organize a tenants committee, and wondering about, because I don't live in a park, but, working out, understanding it's like having a tenants association just already set up. I mean, even still, the owner, if he doesn't, they just count on the tenants not doing anything.
Mm-hmm.
But if that place sold for, I mean, they must sell for millions of dollars.
They do, yeah.
So I don't know if that's just something that I grapple with as somebody who writes rules and wants to strengthen the rules with the legislature, and the what we have right now in the ORS. Just more ideas on how we can make it more stronger so that this doesn't happen.
Yeah, that's a great.
And thanks so much, Samantha. And I don't know. I don't answer the phone, but when people do call, sometimes I fill in for Judy and Ken. And, it seems like every single person is like mediation, because there's really nothing else that we can say. But if you have any other ideas, that would be great. And maybe this is going beyond your meeting, and thank you so much. It's great hearing about your job.
Thanks. No, Shauna, I think that is a great point. I think number one, having that tenants association set up early and having that in place is crucial, because 15 days is just not enough time. So you have to have something in place if you're really going to take advantage of that rule. Ken and I have talked about this a little bit about like the enforcement mechanisms contained, because, landlords are supposed to have their managers go through training, and they're supposed to give you guys notice of all these things. But if they don't, there's not really a consequence, and so Ken and I have searched the ORSs. We're like, there's got to be something, and there's nothing, and so that might be a legislative fix that we need to talk about and think about how we can make that better, because I think it would be way more impactful if MMCRC could impose fines on landlords who are not following those specific things, like, right, just the training and the notices. I think it could just be those two things, but if there's no consequence, why the hell would they do it? I
think right now the only consequence is if they don't register, then and Judy can say better. I'm sorry, I do know this, but I think they get a fee imposed.
Right. But only for registration, right?
No, for landlord training too, as well.
Oh, training, right. Training registration.
Okay. But even like the registration, it's not up to date in a lot of places. So they'll like register the park, and then I'll go onto that registry to find out who I should be contacting because I've got a client in a park, and I'll call that number or that person. And then they're like, who the hell are you? What are you talking about? I don't work there.
Right. And that's the other thing, but I know it's a bigger issue, but I do appreciate that, it's kind of on the same, what you're describing, I think, is the situation. And just a bigger issue of, manufactured housing is such an amazing low income housing option, and, strengthening the tenants' rights would help so much.
Yeah, I really think that the future of manufactured housing will be in co-ops, so tenant-owned co-ops, because even in low-income manufactured housing projects, like St. Vincent de Paul has a ton. I almost always have St. Vincent de Paul clients, almost always. So, these parks aren't run very well. The investment's not going back into them. They're paying their managers really low amounts of money. There's high turnover in their managers. The clients in these parks have so many different issues. They're getting harassed by their manager. It's a whole mess. So the legislature put a bunch of money into doing kind of these low income manufactured housing projects. And I feel a little bit concerned about it, only because my experience with the people who run these lower income manufactured housing parks are kind of terrible. So, and that just comes through consistency, continuing to work with them. Like I said, I'm almost always in contact with St. Vincent de Paul about one thing or another. And I've been able to kind of do some things to kind of help it out. But because I think, once you get higher up in St. Vincent de Paul, you have better paid employees and more committed employees and more consistent employees. And then as you trickle down, then you get, less pay, less benefits, less whatever. And so then that's when you're getting the more turnover. So what I've kind of done is find some of the people that are upper, and I don't even talk to the park managers anymore. I just go straight to corporate, because the park managers are impossible to get a hold of. Sometimes St. Vincent de Paul will be like, that's not our park manager. And I'm like, well, it says that it is online, and I have emails that this person is presenting themselves as your park manager. So that's alarming, you know? But yeah, I really think like even the low income housing, your rent might stay low, but you're going to have a plethora of other issues in your park. So I think that really the future is these co-ops, which requires a ton of tenant organizing, right? And so I think it's my next slide, but I will be talking quite a bit about tenant associations and encouraging people to have them and get an OSTA chapter, have an informal one, set up your committee of 7. Like that is really one of the best things that you can do as a park is be organized so that when stuff comes up, you have already this default thing that you can fall back on, that you can talk to all of your tenants, that you have an email chain set up, that you have this stuff, the infrastructure in place to be able to deal with these more stressful events that are on a time crunch, right? Like you got 30 days or you got 15 days. And so if you already have that infrastructure in place, it's much easier to respond. And
Thanks so much. That's
of course,
great.
Shauna.
I think we're on the same.
And does anyone else have questions about rights and obligations before we move on?
What is MMCRC?
I don't know what the double M stands for. Do you know the whole acronym?
Sorry, it's manufactured. Oh, go on.
Marinas.
Oh,
and marinas.
So manufactured marinas.
Community Resource Center.
There.
Thank you.
And we have a website. I'll share the website. I've been updating the website.
Yeah. All right, hearing no other questions, I'll go ahead and move on, but please feel free to relate back to this slide or these questions if they come up later on. All right, so yep, here as promised, tenant associations. So there are 3 pretty much different types of tenant associations that you can have. The first one and the most important one is a committee of 7. It doesn't actually have to have 7 people, but it can have up to 7 people. This is outlined in the law as a way for tenants to negotiate more effectively with the landlord. So the committee of 7 has to be elected by the majority of people in your park, and you have to have an election that gives everyone an equal opportunity to vote. Once that is done, this official committee can negotiate on behalf of the entire park with the landlord. So if there are, say, park-wide issues like there's not enough lighting, or they've closed a common area facility, or they are doing something wrong with rent billing, right? So whatever it is, that all these every tenant in the park is suffering the same harm. What the committee of 7 can do is go to the landlord and actually force the landlord to come to the table with them at least once a year, but up to 2 times, but landlord's only required to do it once, is actually sit down with the committee of 7 and negotiate these rules and negotiate about the problems in the park. The one downside to the committee of 7 is that the law doesn't really contain, so it's not even a whole statute, right? It's just one section in a different statute that creates this committee. And that little section doesn't have a whole lot of information about how to hold the election, but the election must be elected by the whole, not appointed by the few. And your landlord absolutely 100% will ask you what your method for elections were. So having that kind of stuff written out, having someone like an election coordinator that keeps the records of all of this, that's a really great idea, because once you've formed your committee, I can guarantee that your landlord will say, well, how'd you form the committee? Is it really a committee of 7? Every single time I've ever worked with a committee, that has been the first response I got back from a landlord. So making sure that you have a good record of the election process and how you guys held the election and how you voted, how you counted the votes. That's all going to be really crucial in terms of legitimizing your committee of 7 in the eyes of your landlord. The second thing that you can do is form an OSTA chapter. I think all of you know OSTA is the statewide tenant association for manufactured home parks and floating home marinas. You can become an OSTA member, or you can create an OSTA chapter at your park. OSTA is great because, like I've been talking about, if we can kind of see ourselves as a community of manufactured home park and marina tenants, and that, you know, every time we push our rights in one park or one marina, that's helping everyone else, right? And so if we can kind of start thinking about our individual rights in relation to our community's rights, I think that's going to be really helpful in terms of making sure that everyone is being protected by the law and not just a few people here and there, right? OSTA is a great way to do that because OSTA is connecting parks from all across the state. So if something is going on in one park, you can alert OSTA to that, then it's also information sharing. I mean, there's so many wonderful things about OSTA, and I'll give maybe Angela a chance to kind of speak about OSTA at some point here, but I highly recommend that you guys join OSTA as members and create a chapter in your park. There are just a lot of resources that you can get when you are a member of this larger committee, right? And then the last thing that you can do is an informal tenants committee. These are mostly just committees that, you know, a couple random people are like, oh, let's do it. And you don't have to have a specific election. You don't have the legal authority to negotiate on behalf of park residents. But you can use these informal committees to help foster a community in your park and also to help foster support. So if you have an informal tenants committee and a member of your tenants committee, say, gets a notice of termination, they can bring that to the tenants committee and get the ideas from other people in the park, right? So it's just a really great way to not feel so alone and so isolated, and to, you know, do community events, to just be able to sit there and, you know, bitch about your landlord for a little bit, right? Like there's a lot of really cool benefits, I think, of having a tenant committee, even if it's not one of these formal like OSTA chapters or a committee of 7 where you have that legal authority. Just having that, like I said, that infrastructure in place where like maybe you have an email address that is like XY Manufactured Home Park Tenants Committee at gmail.com, right? Or, you know, you can set up like a registry with that, right? So you have everybody's numbers and you have a phone tree or whatever it is, right? But it's having that infrastructure in place at the beginning, like as soon as you can before issues arise, really, really helps people not feel so alone and helps them get the support and help that they need. And you don't have to do really anything to create an informal tenant committee, right? You just do it. So this is my wholehearted pitch to create some kind of tenants committee in your park and to just really stay connected to your neighbors. Remember that you guys are a community and you're stronger together than you are individually. And I see that Ken's got his hand up.
Make sure I've unmuted myself, but yeah, I want people not to get hung up on the committee of 7. Statute doesn't commit to any solid number. And that 7 is the number of officers that you can have. Other than that, you could have a committee of 7 that actually has 3 members or whatever. So don't, misconstrue that scenario. And I've been toying with an idea of putting together, actually, I do have kind of a rough bundle of documentation that when I find out that a new park is it's changing hands, I send it to whoever is calling. Sometimes it's an OSTA person, but it might be time to kind of gussy it up because it is pretty rough. And I'll talk with Samantha about that a little bit later. But that's the one thing that people misconstrue. And statute does require that if you do have a tenants committee, you have to provide a 1-page notice to the landlord explaining that you are in fact have elected a tenants committee. So we've got a lot of accumulated information that we can bundle. And I'll talk with Angela and yourself on that a little bit later.
Yeah, I think we can totally get something updated. I know Angela has created a really amazing packet that's got tons of information about tenant committees in it. I believe that's available on the OSTA website. But yes, Ken, you're completely right. You don't need to have 7. I think it's like up to 7 is what the statute says. So yeah, it can be, don't put more than that, I guess, but
yeah,
you can definitely have less.
Yeah, they can have 7 officers.
Yes.
So can you have 12 people, but just 7 are officers?
Yeah, sure.
And so, the committee of 7, right? Like you have the officers who those will be the people that actually meet and negotiate with your landlord. But theoretically, everyone in the park is a part of the committee, right? Because that committee, it's kind of like thinking of like your representatives, right? So we have House representative or like our Senate representatives. We've got 2 people that represent the state of Oregon in the federal level, right? And so it's kind of it's that idea that like, yeah, you're there. They're the ones doing the negotiation. They're the ones actually talking to the landlord, but they're supposed to be representing everyone's interests, right? So it's not just like these people get elected and they can do whatever the hell they want. They still have to, meet with the tenants and make sure that the whole community of tenants, that they are understanding what those people want. That's kind of the idea, right? That they're supposed to represent the park and the park's needs.
In the materials that you have developed, I know people in our park are already connected with OSTA. I'm new to it myself, but we're trying to build community involvement and interest and educate. Do you have some resources we can look at on the website or something that takes care of that?
We haven't put it on the website yet. I believe it's on OSTA's. He has a version that's on their website.
On OSTA, okay.
Yeah,
we do. We have a guide that's printable and downloadable. It's a PDF. It's a guide to residence committees, which includes a committee of 7 and a chapter and an informal tenant committee and how they're different. And then it even goes so far as to give you some, ideas about how to run each of these groups and how to go about establishing them and some ideas for marketing it as well to your community. And I would like to piggyback on something Ken said. The law does require the landlord to give every prospective purchaser at the time they apply to become a tenant in the facility this 1-page summary of a tenants committee. Well, the landlord doesn't have to write that. The requirement is that the tenant committee write that summary, deliver it to the landlord, and then the landlord can deliver it to the new incoming prospective tenants. But what is genius, like don't squander this opportunity, because it is absolutely genius and imperative to be able to get someone on the way in who's possibly coming into the community, purchasing a new home, to say, hey, look, we exist. And if you have any questions during the process, just give us a call. This is not the time to talk about how crappy the landlord is. Don't ruin your neighbor's chance of selling their home. But just to say, hey, we're here for you. Mm-hmm. And then come to a meeting and try to grow your committee like that, because in every community, there's going to be some group of people who don't want to rock the boat and don't want to attend a meeting and don't want to participate in that and want other people to do it for them. So getting people on the way in is an incredible way to grow your community and your chapter and your tenants committee and power.
Yeah. And I think that's such a good point, Angela. And also, there can be issues when you move into the park, and Angela knows very well of all of those issues. And so I think if that person, the new person that's coming in, they're probably going to run into some issues. I mean, it's just kind of inevitable. And if they know that there's a community and a committee or other neighbors that they can talk to and get support and even help, maybe, right? Like if your committee, they know that MMCRC exists, they know that OSTA exists, they know that I exist, right? And they can help funnel people who don't know anything about this law to to the people that they need, right? And to actually protect their rights. And so not only is it great to just kind of pull in those people and get the buy-in from the beginning, but you can actually provide that, the existing committee can provide that new person with a lot of really helpful support so that they can actually start their tenancy off on a good foot instead of having like a terrible, awful experience and then end up moving, like what happened with Angela, you know? And so it's like, I think having that support from the very, very get-go is so crucial. It really is.
Yeah, it's not illegal to encompass some sort of social activity as a sidebar with your tenants committee, because again, that's bringing community together. And people may or may not participate. Maybe it's a cooking club or whatever, but don't be afraid to adopt those sidebar issues to kind of give some foundation breadth to your tenants committee.
Yeah, I think that's a great point, Ken. But also it fosters relationship, right? And it's hard to go to a stranger and say, I don't have the money to pay my rent this month, and I'm going to get a notice of non-payment. What do I do? That's hard to say to a stranger. But if you are friends with the people that live in your community, if you have potlucks with them, if you guys do like weekly walks or whatever it is, right? You develop these relationships where when something negative comes up, you have the confidence and the comfortability to share that with the other tenants in your park. Oftentimes, a lot of people are suffering from the same issues with the landlord. And unless you guys are talking about that, you don't know that that's happening. So I completely agree. Like any one of these types of committees is so important. And if all you do is an informal tenant committee, that still is incredibly important and useful in your park. And it gives you that opportunity that if for some reason you're like, okay, we need that committee of 7, we need to push this landlord to come to negotiation, you've got the infrastructure to make that happen. Yeah. You have people that are already involved, that already, you've got an email address set up, whatever it is, right? But then you be like, okay, I'm on the informal tenants committee, I'll be our election officer, right? And so it really, you don't have to start out with the most complicated thing. Start out with something simple and build your way there. But having something in place is really, I think, the best thing that tenants can do in these situations.
And meet
without legal help, right? Sorry, Ken, what was that?
They need to meet regularly and not just when there's a crisis.
Absolutely.
And that alternate activity is something that will hold people together.
Absolutely. I think it's a great point. And it's, you feel so much less alone when you have people to commiserate with, right? So even if it's just, wow, the weather's been so crappy, our streets are all wet constantly, whatever it is, right? Like it doesn't have to be a huge issue, but when you can just have other people that are in the same boat as you with the same things going on, it really builds such a sense of community that then empowers people to try and push back. It really does. I know that seems silly, but it really does.
All
right.
I was late coming in. I apologize for being late coming in, but did I see something at the beginning when I first opened it say I could watch the whole thing again somewhere?
Yeah, it's being recorded.
And how do I access that?
It'll be posted. Usually we send it off to YouTube, but it takes a couple of days.
Oh.
So, give us a couple of days and then we'll send a notice to folks in OSTA as to where it's at.
Oh, okay, great. Thank you.
All right. And so I'm going to just briefly talk about, I know we're kind of approaching the end here, so I'm just going to briefly talk about the eviction process. So the way that the eviction process works, I think a lot of people get the termination notice and it says, if you don't do this by this date, then your lease is terminated. And they think that that means that they have to move out and that they're evicted on that date that it says do this or leave by this date, right? You are not evicted at that point. In order to be evicted, you have to have a court order that says this person is evicted. Landlords are not allowed to self-help. So a landlord can't like force you to come get out of your house. They can't change the locks on you. They have to take you to court after. So you'll get the termination notice. It has a period where you are allowed to cure that violation. Usually, some of them don't, but almost all of them do. And then once that notice period is over, if you haven't completed the things in the notice, or it was one where you couldn't cure it, after that notice period expires, then your landlord has to file it with the court. And that's when they file a complaint, an eviction complaint. Then the court will send you a summons with a court date on it. That court date is not your trial. You're not going to go before the judge and explain to the judge why this is false or why this is true or whatever it is. You're not talking to the judge in this appearance. Basically, what you do in this appearance is the judge will explain that you have three options. You can either settle your case with a court order, which is very unique to evictions. So it's not a settlement off the record, which is what normally settlements are, that they're not actually a part of the court record. They're not public information. But in FEDs, they are. So in evictions, your settlement is actually a court order. And if you don't follow what it says to do in that court order, in that settlement, then your landlord can get an eviction against you immediately. And this is public information. So it's a public document in your case file. It does seem very attractive, I think, to a lot of tenants, and a lot of tenants end up signing these agreements at first appearance. I want to warn everyone that often what happens is that you'll sign this, and then once the period of time, usually they'll give you 30 days or something to do it, that your landlord's going to file a notice of noncompliance anyways. And at that point, you've waived your right to trial. So all you can do is go into court and say, no, I really did comply, and show that you really did comply with the court order. Otherwise, you're evicted. You can't, at that point, you can no longer go back and attack the notice itself. So like attack the reason why they gave you the notice, or maybe there was something wrong with the notice. Like I explained before, all those like really specific things they have to include, that if they didn't include one, you as the tenant would win. But even if that's there, the notice is wrong, and you decide to settle, you've waived your right to trial. So it is a risky thing to do. It seems really beneficial. Judges like it because it takes a case off the docket and they think that it's maybe more fair for everyone. But it is really a risky thing to do. So it's something you really want to think about. And if you do enter one of these agreements, that whatever you agree to do is possible, right? A lot of people agree to these things that I'm like, there's no way you can do that in 30 days. So you got to think about like, okay, is this really possible for me to do? Can I actually do this in this amount of time? Because if you can't, then really all you're doing is stalling your eviction to a later date. The second thing that you can do is request trial. I recommend only really requesting trial when you have a defense, and that can be a factual defense, a legal defense, a notice defect, right? There's lots of different defenses that you can have for an eviction. But once you've requested trial, you are at a much more likely position to be stuck with a bigger judgment at the end. Like we talked about fee shifting, right? So if you request trial, that fee shifting will apply. And if they hire an attorney to represent them at trial and you lose, then you could be responsible for paying that attorney's fees. So, trial is a risky thing to do. But if you have a defense, it's a great way to do it, because then if you win at trial, now the landlord has to pay for your attorney's fees and your court costs, right? And so it's more than just a slap of the wrist where like, okay, the case gets dismissed and they lose $88, which is what it costs to file the case. They'll have to pay thousands of dollars, right, for filing a bogus case. So I do think that requesting trial is an incredibly important thing to do, but I highly recommend reaching out to your local legal aid office or me before you do that. We have an entire team of eviction lawyers. I think we have 15 eviction lawyers right now, a part of our eviction defense project. All they do is take evictions. So we do have quite a large staff of attorneys that are available to represent in these eviction cases. If you're going to request trial, I highly recommend doing that with an attorney, because getting evidence in and proving your case and following all the rules of the courtroom is tough. especially if the landlord has an attorney, because they're just going to object to everything you say and everything you try to put into evidence. So if you're going to go to trial, highly recommend trying to get an attorney beforehand. Remember, we are free. You just have to qualify financially. I have a much higher financial eligibility requirement than most of OLC, the legal aid does. So if you don't qualify for regular legal aid, then you can always come to me and you'll most likely qualify for me. The last thing that you can do, which I never recommend doing, is concede the eviction. That means you're saying, yes, I did these things and I stayed after and I'm wrong. Okay, bye. And then you have an eviction on your record. Judges won't at that point order like a prevailing party fee or attorney's fees generally if you concede, but you'll still have an eviction on your record at that point. If you do request trial, then your trial will be set anywhere from 2 days to 2 weeks out from your first appearance date. It depends on the county that you're in and the amount of cases that county is taking. I know, for example, Lane County sets their trials very quickly, usually within that 2 to 3 day window. But other courts wait a while and they set them out 2 weeks to 3 weeks out. So it really depends on where you're at in the state to how quickly they're going to set your trial. But basically, requesting trial isn't necessarily, I think the reason why they do that is so that requesting trial isn't a stalling tactic to just stay in longer, right? It really does come up quickly. And so you need to know what your defense is and be prepared to put that defense on really shortly after that first appearance. I would say this is, again, another reason why building that record throughout your time in the park is so important, because you don't want to show up to your first appearance, request trial, it's in 2 days, and then you've got 2 days to tear your whole house apart to try and find the documentation that you need to prove your case. You want to have that stuff accessible. You want to have that all of your communication with the landlord in writing, right? You want to have that record that is accessible to you, available to you, so that when you go talk to an attorney, you can just give it to them, or when you go to trial yourself, you have everything that you need to prove your case. Like I said, because it's so quickly, you don't have a lot of time to prepare in between first appearance and trial. So having the documents and the record that you've built during your time as a tenant is crucial in order to be able to prove your case at trial, right? And so do I have any questions about the eviction process? I see there's a couple chats here. Okay, seeing no questions. Let's see. All right, well, it looks like we're about at time. I do have some other stuff on here, but I want to allow for some questions. And, we're happy to do these kinds of presentations, and we've got the materials out there. So if we want to, schedule another one of these to talk more specifically about what you can be evicted for and how those notices need to go out, I'm happy to do that. Oh, Marilyn, it looks like you're muted.
You do have a website?
Yeah, so MMCRC has a website, OSTA has a website. The website for Oregon Law Center is just www.oregonlawcenter.org. And I am based in the Lane County office. So if you need to call, that's the office to call.
Thank you.
I would normally be giving you guys my direct dial number, but unfortunately, my organization decided to switch our phone service and my phone number. So I'm kind of in this weird in-between time. I get a new phone number on July 10th. So I don't want to give out my other phone number because it won't work very soon. But you can always find me through Lane County office, and my email address is on this PowerPoint, and I'm happy to circulate this PowerPoint as well. So you can always get in touch with me by email, or you can call the Lane County office and they can transfer you to me. And then once I have a number, I'll distribute it out to MMCRC and OSTA, and hopefully we can get that circulated around to people as well. Here, I'll just go to the end so that my info is up there.
Hey, Samantha, this is Mike. We had a situation happen about 3 years ago. A submitted rule change that actually came from our OSA chapter. We met with the, we do meet with the park management quarterly. Anyway, we submitted this rule change, and they screwed it up with the submittal to everybody. That anyway, some things in it were timely. And they didn't include everything, the requirements. So they had to resubmit it about a month later, month or two, I can't remember which. Well, everything was included in it and the things we wanted, but they still did not satisfy all the requirements as far as being timely and inclusive in their submittal to everybody. So we just kind of let it die because, and it went out for a vote. And like you said, the only people that, only votes that counted were the ones that were objected, because if you don't, you imply you're agreeing with it. So what's your take on that, about just ignoring it since they didn't have all the requirements in place?
So, and this was a rule change that you guys requested?
Yes, it is.
Okay. And is it something that is like requires the landlord to do things? Like, is it an obligation on the landlord, or is it more something that you as tenants are supposed to follow?
It's something the tenants are supposed to follow. Actually, it had to do with political signs.
Oh, okay.
And we had so many of them. Our proposal was one sign, whether it's a banner or a sign per residence, instead of we had people that had a dozen of them, and we thought that was tacky. So we anyway, we submitted this proposal, and it didn't go. They resubmitted it to everybody because they didn't have all the requirements in place when they put it out to begin with. So the second time we just said, oh, it's fine, just let it go, because we're tired of screwing with them.
Yeah, I mean, I think that that's really like a personal decision for your guys' tenants committee to decide of whether it's something that's worth it to push them on or not. I'll tell you that landlords are really bad at following the rules about rule changes. Like, I don't know if I've ever seen it done correctly the first time. So that doesn't surprise me at all that they could not get it together to do it correctly. You know, if it's something that's really important to you guys, and let's say, like, you know, we've got an election coming up soon that might be a lot. So it could be worth it to bring it back up to them. Yeah, unfortunately, if they can't get the notice right, then it's, you know, you guys can't really do much about that, other than, you know, I guess you guys could try and draft what the notice would look like so that it includes the correct information, and then provide that to the landlord to, you know, reissue to everyone with maybe more detailed instructions of how to do it correctly.
Well, actually, we did. There was a couple of us that the manager leaned on for the actual language to submit it. So they took our language verbatim. So it wasn't like we didn't have input, but
yeah.
Anyway.
Yeah, I don't know. That's a really unique situation. But, you know, I think that if it's something that's important to you guys, then why not keep pursuing it, right? But I think at the end of the day, it's like, that would be a low, in my opinion, that's just kind of a low priority, because it's not the landlord trying to impose rules on you guys, but you guys trying to impose rules on the community. And so I think that really it just has to go, you know, how important is it to you guys, and how much energy do you want to put into this issue, right? Now, I would be more concerned if the landlord kept trying to change your guys, like on their own, try and change the rules for you guys and doing that incorrectly. I think I'd have more to say about that. But I think in this case, it really just depends on how much energy you guys are willing to spend on the issue.
Thank you.
Mm-hmm. Not meaning to do that.
Samantha, I have a question for you. It's Angela.
Hi, Angela.
It's never occurred to me to do this, but we do get calls and emails about people who are asking that question that commonly gets asked. Hey, our new park owners have come in and they're expecting us to follow new rules. I mean, I never thought about this, but I could ask, well, when did your new owner come in? And did you get the opportunity to try and purchase? Did you receive a notification before you received a new owner?
Mm.
And then if they haven't, and it's been within 1 year, which I believe is what would be allowed under the statute of limitations, where can I direct them to find out more information about how to proceed to get access to that 10% or attempt it?
Probably Oregon Law Center. I would go straight to an attorney in that situation, because MMCRC doesn't have any like regulatory authority over that. And so I think it would have to be a private, well, we're public, but you know what I mean? It can't be the state, I think, that's doing it.
Correct. I promised to start asking that question. I just never thought about it because I know the law is new. It's a new part of the law, this 10%. So what was it? Was it 2023 or 2022 that it took effect? But to tell people,
mm-hmm.
Hey, you didn't get a right to compete, then you guys might have a good shot at some stuff.
Mm-hmm. I think that's great. And like making sure that that's known as early as possible, because bringing an affirmative claim does require work, because you have to do all of your research, all of your legals, everything has to be done before you file that complaint. So, there's a lot of work that happens before you even get that complaint in, which is that complaint has to go in within that year. Right. And so it's like, if I get the case right before the year mark, there's really nothing I can do about it. But if I get it 6 months before, then we've got a couple months to gather the evidence that we need, put our case together, get the complaint done, and then submit it beforehand. So the earlier that we can catch these things, absolutely the better. At least the much more likely that we'll be able to do something about it.
That's great.
Yeah. Yeah. And I think too, like really hounding in the idea and the principle that a new owner cannot force you to sign a new agreement. They cannot force you to follow new rules. They don't get to just automatically come in and like provide new things. They're stepping into the position of the old landlord. And that means that you could have 20 different contracts and 20 different rules in your park, and they can't just change it for everybody, right? Like you made a deal based on your rental agreement and your rules and regulations when you moved in, and that is your contract. So that might be different. It can be different within a park, but that's there for your protection, right? Because as new contracts come out and new rules come out, like Angela mentioned, they end up being 16 pages long and contain 100 million rules. And it's really, you're going to have a much more favorable contract that you signed, say, in the 70s than you would now, right? And so sometimes people in parks are like, we want the new rental agreement and the new rules so that we know what this manager expects. And I understand that desire. And yet, by asking for that, you're like waiving your own rights. So don't do that. Don't agree to sign new rental agreements and new rules and regs. Even if it's a little confusing, you're going to be much better off on your old one than you are on a new one.
Well, and to piggyback on that comment too, I mean, what we experienced within our own community when we got these pages and pages of rules is that some people were like, well, I kind of like these sets of rules, like these 10. And someone was like, well, I really would like number 24 to be a rule. I think that's reasonable. But you don't get to pick or choose in this vote. It's either yes on all of them or no. So even if you as one individual community member like rule number 24, you can live with the rest of them. Think about your best friend next door who may have to leave the community because they are no longer in compliance and they don't want to comply with those rules because, they have something or use the space a certain way. I mean, guests. Some people in our situations, they have these homes where they're grandparents and they have grandchildren that come over. And then the new rule says, oh, you can only have overnight guests 5 times a year. Well, you might like rule number 24, which was about, hanging baskets, and that one you might really want, but think about rule number 89 that's preventing Sarah next door from having her grandkids over. Mm-hmm. So it is a negotiation with your community.
Mm-hmm. Absolutely. And the overnight guests and parking are two things that I see people get evicted for all the time. So those rules, like, even if you're like, oh, it's a guest rule, they don't really care, right? Like, I mean, I've lived in so many apartments and had guests stay over for weekends and no one's ever said anything to me about it. Parks are not the same. Your manager almost always lives in the park with you and walks around the park and snoops at what you're doing and sees everything happening. And you don't get away with as much in a park or a marina than you do in an apartment. And so even if you're like, oh, that's reasonable, just like, is your landlord going to be reasonable? And the answer is almost always no. So, just assume that your landlord is going to be unreasonable about enforcing the rules when you're looking at them. Even if you think it's reasonable, is it going to be reasonable when it's enforced against, when the 84-year-old across the street can't mow her lawn and they won't let someone else do it for her? Like, it's like, it can get into a place where it really hurts people, these kinds of rules, and the way that the landlord tries to enforce them. So vote down every rule that they do. I'm all about voting them down. Just vote them down. You can follow any rule that you want, but you don't want to be able to be evicted for that rule, right? And so it's like, even as tenants, if you have a good tenant committee and you're like, look, we really don't like that everyone has broken pots everywhere. Like, that's really annoying to us. So why don't we, as a community, say, okay, if people have broken pots outside, let's pull some money, let's replace. Like, you can do that yourself. You can enforce things just through community norms, right? And through, if someone's like, I don't have the money to do my landscaping, and some people could be like, oh, well, I can help you with that. Or, we've got an extra thing you can plant, right? You can really build so much more. Community is not the right word, but it's more enriching, and you can have a park in the way that you want to have the park without having to be evicted because you have a broken pot on your porch. Like, that is absolutely absurd. You own that home. So much money is invested into that home, and to be evicted over a broken pot is like the dumbest thing in the world. It's just so stupid, but it can happen if you allow the landlord to adopt those types of rules. So just don't let them do it. That's why don't let them do it.
Agreed.
So I have a question.
Yeah.
We did just get a new set of rules, and people are saying I'm not going to go with that. So if you don't agree to go with the new set of rules, do you have to do something to let them know you don't agree, or do you just? I missed the earlier discussion. That's my fault. I'm sorry, but.
No problem. Yeah. So yes, you absolutely do. And it sounds like I don't know the whole situation, but if your landlord just sent around a new copy of rules without anything else, then that's not legally valid for anything. So in order to change the rules that you guys already have in your park, because this is a new owner, right?
No, it's the same owner.
Oh, it's the same owner? It
was one company, another company bought it, same managers.
Okay.
And then we've had the new owner for a year or two now, but the new rules just came out, and I haven't looked at in big detail, but I'm just hearing people say, I don't like this, I'm not going to sign this, or I'm not going to agree or something.
So in order to change the rules in the park, they have to send you a notice that explains that according to this law, we're allowed to change this rule for this reason. This is the old rule. This is what's changing in the rule. This is the new rule. You as tenants have a right to vote this down. If 51% or more of eligible spaces vote against this rule change, then it won't come into effect. They have to give you that notice with the new, and explain it all. They can't just give you a new set of rules and say, follow these now. And that's what happened in Angela's park. I don't know if you heard her story from before, but and Angela, do you want to just quickly explain that, how you guys ended up getting those rules to be?
I will listen to it when you get it on the website or YouTube or whatever it is. I can listen to it then, but if you want to take time, that's fine as well.
But basically, what you can do is, if they haven't provided all of the proper notice, send a letter. And you said you have a tenants association and OSTA chapter and stuff?
Right.
So I would get together.
Not really flourishing right now, but we're hoping to get it flourishing.
I would get together with some of the members that are active and draft a letter and to your landlord that just says, dear landlord, this set of rules is different than, what we had when we signed our rental agreements, meaning this is a rule change under the law. And in order to do that, you have to do like X, Y, and Z, and we can provide some language for that. Maybe we can do like a example letter or something that we can get up on OSTA or something. Angela, I'll work with you on that and get something to you. But yeah, so basically you'll just want to send the landlord a letter saying, you're not doing this correctly, so this means nothing. And what happened for Angela's park is that when they sent that, they had so many new rules, like 16 pages of new rules, that in order to change them, they would have to go in, put the old rule, explain the differences for each one of those rules on those 16 pages. And that would take so much time and energy and effort that the landlord ended up just revoking it and didn't try and institute new rules at all. So I think that, making sure that the landlord knows that you guys know that he's not doing this right, or that they're not doing this right, that's really important. And that might even stop the whole thing in its tracks. And if it doesn't, then there's always the option of coming to me or coming to another legal aid attorney and doing a demand letter or something like that to get them to revoke.
Thanks.
And two, I would just add that if you do review those documents and it turns out that they have complied to the law exactly how the law prescribes it, but there are new rules that you don't agree with, doing nothing, taking no action means that you're voting to accept the rules.
Okay, I think I heard that when I first tuned in.
So the way the law is written is if he proposed, okay.
And you only have 30 days to do that from the day that they send it to you. So if they have complied, you have 30 days to vote it down. Okay. And then in 60 days from the day that it was served, then that's when the new rule will come into effect.
Okay, it may be past that time frame. I'll have to check and see. Thank you, girls.
But it sounds like, if they're just sending out the new packet of rules and it's not an extensive packet that explains what the old rule is and how that's changed and has the information about voting it down, then it's not in compliance. And so then that time period doesn't really matter. So it kind of depends on which situation that you're in.
Okay.
But like I said, I've almost never seen a landlord do that correctly, at least not the first time. So it's very highly likely that they've done it wrong. So
okay.
Worth sending the letter, I think.
Thanks. Appreciate it.
Okay, then. I guess we've extended our time. We haven't been booted off by another party, but certainly we can love to hear feedback from people in terms of what they liked, what they didn't like, or topics that they want to delve into deeper. And we'll take it from OSTA, from the attendees as we receive that information via email or phone, whatever.
And we can take all that info and make sure that we cater our next presentation to the things that you guys are looking out for and the things that you need more information on too.
Got a quick question. Going back to that 51% rule, is the location that I'm in is that they're refusing to say that they have to comply with anything within the 51% rule, that they arbitrarily, the new rules and regulations for the new tenants, all the tenants start to follow that without issuing a change to the rules to give the opportunity to the tenants to vote on it. So in those particular cases, what steps can be taken to rectify it?
So, I think, again, sending a letter to your landlord and just saying, hey, just FYI, you never did the rule change process, so these are not our rules. That's one thing. Now they can, for new tenants, they can give them new rules, right?
Yes.
I think one of the best things to do in that situation is to make sure that everyone who is not subject to the new rules understands that they're not subject to the new rules. and kind of like what we talked about before, is that landlords will make it seem like you have to do stuff because they can kind of bully you into doing it rather than going through this whole process. It's time consuming. They have to hire a lawyer because it's really hard to do it right. It's a lot of text that they have to do to change the rules. And so they don't want to do that. They just want to informally make people follow these rules. So, I think that setting a letter and making sure that the landlord knows that you guys know that that's not legal and he can't change your rules that way. Also, if your landlord tried to evict you, or, mostly evictions. So if your landlord tried to evict you or charge you a fee for a rule that you're not subject to, then you have a defense to that eviction that is, this is not my rule. And so they would have to then prove that they went through the rule change process and that actually is your rules. Right. And so, they couldn't do that because they didn't follow the rule change process. And so then they would lose. But there's not like a separate enforcement mechanism to, it's basically like you're not subject to that rule. And if your landlord tries to enforce that rule upon you, then you have a defense to it, is more so the protection that you're getting there.
Yeah. Well, as far as talking about the owner has not responded to any of the requests from any of the residents regarding the rule changes.
Well, also, actually, Jim, you can request mandatory mediation. Every individual is entitled to mandatory mediation. So you can do that. It doesn't guarantee you a result, but it does stop things in process until it's, it buys you some time to get, more organized. And if you can do it, make those letters or petition to let them know how many people don't appreciate what was done. So there's somewhat of a show of force there. But if he intends to be belligerently ignorant, then it's ultimately going to wind up in court.
Well, it's also the process that we went through is also to go to the property manager, which is Commonwealth Real Estate, and the vice president has also refused to acknowledge it. He's gone to the fact that they have had their attorney write me 3 threatening letters to cease and desist any further action.
Yeah, who they hired is it Mark Bush?
Pardon?
Do you know who their attorney is?
Yes, I do.
Is it Mark Bush?
Yeah.
Is it Greff? G-E?
Oh, okay, Charles. Yeah, okay.
Charlie.
Yeah.
So, and I even turned him into the State Bar Association because another attorney had said, yeah, he shouldn't be able to do that. So, but the Bar Association didn't do anything. They find it acceptable.
That's kind of the problem when lawyers regulate lawyers. It's like, it doesn't really make a whole lot of sense. We write our own ethics rules. We regulate ourselves. It's like, what are we doing? What are we doing here, people?
Yeah, the vice president of Commonwealth give the on-site managers the autonomy in enforcing these rules. And that person says, no, those are void and you can't do anything about it. And if you try, I will evict you. She's arbitrarily already taken and posted 3 eviction notices on different residents just to scare them.
And did she end up filing them or just
she's being successful because majority of the people here are 70, 80s, and 90s. And so they're scared to death because they said, we don't have any place to go.
Right.
And we won't be a burden to our children. So we're just going to have to take the beating.
Yeah. Yeah. And, I think this is one of the hardest things to overcome, especially in 55 plus parks, is the fear. There is, and while, manufactured home parks remain a good source of low income housing, it's also kind of a trap in a lot of ways because you're investing a ton of money and a ton of your resources into this home that is yours, but then you're stuck on a plot of land that is someone else's, and you're basically subject to the whims of whomever takes over. And so, last night I was at a park that had great management for years and years and years, that had the same manager for 11 years. And then a new person came in and now all hell is breaking loose, basically. Right. And it's like, unfortunately, really the only thing that you can do as residents when you have a bullying manager is come together, organize, and make sure that that person knows that you guys know your rights. And that is a really hard thing to do when you have that much fear, right? Because all they have to do is evict you, and now you're homeless and you can't get your home. I mean, I get it. Trust me, I understand how terrifying people are. And at the same time, if we get stuck in that fear, we're never going to get to the point where we're enforcing our rights and we're getting the case law that we need, and we're getting judgments against landlords to scare the landlords finally so that they will follow their right, follow the law, right? So it's like, it's kind of this balancing act that we have to perform of like our fear and protecting our rights, because our rights won't protect themselves. We have to do that for ourselves, right? And a landlord, they look at you guys as money signs, not as people. And so I think it's important that the tenants come together, that the tenants support each other as important community members and human beings, and that you have that sense of support in your community. But you're never going to get that from your landlord. I mean, maybe, but that would shock the hell out of me if you did.
So
right?
Samantha,
Like,
if they, should they wait until they get an eviction notice and then call legal aid?
you can absolutely do that. Yeah. And if anyone gets a legal aid, or if anyone gets an eviction notice, have them call legal aid right away. Like I said, we have an entire team of attorneys that all they do is evictions. So they can't actually represent until the notice is filed in court, but there are lots of other attorneys that can give advice during that notice period, including myself. But yes, once there's a termination notice, people should be reaching out to attorneys, to legal aid. And there's LASSO, which is the Legal Aid Services of Oregon, and also the Oregon Law Center. There's 2 legal aid organizations, and between the 2 of us, we have offices in every county of Oregon. So there is always going to be a legal aid attorney available, or at least in your service area, maybe not available at that time to take your case, but it's always worth it to try, call, do an intake, and see if you can't get that help from them.
Yeah, as far as the evictions, is I'm the chair for our association. We have a committee of 7. We've had it for over 3 years. And so I'm well versed in Chapter 90 and the issues that go along with it. So I wrote letters to the on-site manager, and that person went down and took the notices down. So because found out the person was in the wrong. But yeah, it's just the tactics that they're using right now to scare these people into conforming to whatever they want. Mm-hmm. So we've had several. My problem right now is trying to find attorneys that can take our cases. I found one that we filed a case in, that I filed personally, a case in 2021 that is, I made a civil lawsuit. Mm-hmm. The final will come up in July. Yeah. Because they wanted to drag it out. Mm-hmm. We finally went to mediation, and under advice of the attorney that I have 3 other lawsuits that I want to file. And the only lawsuits that I want to do is having the financial impact on the residents. Right. Because when you get folks that's in their 90s, even the 80s, and they've run out of their surplus money and they're only relying on Social Security, they can't take these hits like they're getting. Yeah. And there was in 2020 and 2021, the owner exceeded the 7% plus the CPI. And I couldn't find an attorney to take the case.
And were you able to call legal aid, or are you over income?
Yes, I contacted legal aid. I've had legal aid ever since 2021. Okay. and the same person, and has been advising me whether it's a violation or not, or if we can take it to court. Mm-hmm. So they've been extremely, extremely helpful. Awesome. in that fact, but they haven't been able to take any of the cases, which is a lack of resources. Yeah. And then when I saw the governor's budget, there was supposed to be more money going into it. Well, it didn't happen. No, we got less money, unfortunately, this year. So we have staffing, we've got a bunch of different positions that we have to freeze. So we've got vacant positions, and yeah, it's unfortunate.
And the resources thing is, it's totally true. I mean, I'm one person and I'm supposed to serve every single manufactured home park and marina in the state of Oregon. So that's
because you've got broad
what are we talking about?
You've got
well, the
broad
landlords
shoulders.
and especially the property managers know that there's no recourses to take because there's nothing we can go to get it done. And,
Gentlemen,
I've
we're
been
going to have to wind this up because we're a half hour over now of our allowed time. And hopefully the next time we convene, we'll have early entry permissible by Zoom.
Yeah.
Okay, so again, thank you, Jim, and everyone for participating. And if you have comments, certainly send them our way or to Osta or Samantha or whatever. And we'll see about scheduling a next session.
Yeah, that sounds great. And Jim, if you want to send me an email with some more information about your park and let me know what attorney you've been working with, and then at least I can link up with that attorney and get it kind of down low what's been going on at your park and see if there's something that maybe I can jump in on.
Okay, that'd be much appreciated.
Yeah, of course, of course. All right, well, it's so great to see everybody. Thank you, Ken, for arranging this. And thank you to Osta and everybody from Osta for sending out all the invites.
Bye-bye.
Thank you, Ken,
You can
Samantha,
go eat now.
Judy.
Yeah. Time to eat. Yes. Bye.
Bye-bye.
Bye.